Our next issue is to consider whether third-party funding is actually promoting access to justice. I thought it would be helpful if I started by asking John, Angus and Malcolm, from your respective research, why is it that third-party funding seems to have been used in relatively few cases so far? I'll start with you, John.
It just seems very early days for a very kind of young and immature market. I mean, just by way of background, it's trying to get some figures on how many cases have been funded. The figure that everyone quotes comes from the Civil Justice Council, which is 100 cases. And it seems from my perspective, there's a lot of talk. I mean, and I respond to this as a journalist, and I read lots of articles in the press. And there's lots of articles about litigation funding, I think, because it kind of intrigues. It's kind of it's an intersection of three different areas. It's the law, it's business, and it's finance. And I think editors find that quite interesting. So there was a spate of articles talking about, is litigation funding going to break through and going to develop into a real industry? And the sense that I got was that it certainly hadn't really done much over the last 12 months. And I know Susan will probably have views on this, because one of the things I suggested to Susan when I was interviewing her, that there's a lot of talk, very little action, and she was quite clear that there's quite a lot of action going on as well. So there were those 100 cases that Civil Justice Council said had been funded so far, and I spoke to Bob Musgrove, and he suspected there might be a few more, but not very many more. And to get a sense of the size of the industry, I went to litigation funding lists those funders who are available. There are now 19 funders listed at the back of Law Society's litigation funding publication, and they're a real mixed bag. They're doing different things, totally different kinds of organisations. So, I mean, the sense I got of it was a very young industry, kind of very, very opaque, difficult to find out what was going on. Some very kind of compelling arguments coming from those small number of established players. But still a bit of a mystery to me.
Thank you. Angus?
I think I'd agree with that on the young industry part. But I think the other thing that we picked up in our research, and Susan may come on to talk about this as well, is the lack of knowledge about funding options on the part of lawyers. One of the things that we're finding is that it's predominantly used by SMEs in cases against larger companies, including in-house people, but they're not necessarily aware of the products that are available, and they don't necessarily consider it at an early stage. As Susan said, in relation to the kind of definition of what litigation funding is, funding can come in at any time, and as the market develops, what we may see is that it starts to come in earlier as people consider at the beginning how they're going to fund the case, what they need, and the kinds of agreements that they can get in. But at the moment, I think it's early stages for the industry, so I think that's a big factor. Lawyers themselves don't know too much about the funding that's available to them, and aren't taking advantage of the excellent products that are out there.
Do you agree, Malcolm?
I also think the numbers are underestimated as well. I think the Civil Justice Council estimate of 100 is out by quite a factor. But the point is, of course, that commercial litigation, there are relatively few commercial litigation cases as compared to road traffic accidents or personal injury cases as such. And you've only got to look at the judicial statistics to see that. So we would expect to see perhaps fewer cases make the headlines. And of course, people don't want to publicise that they are funders. The fact is, the people who need to know are the lawyers and the experts. It's not the general public. It's a professional solution, not a consumer solution. And I think that's one of the reasons that very little is known about it, is because it has not been widely promoted as such for a good reason.
And Gavin, from a practitioner's perspective, I mean, do you agree that awareness among lawyers is a major factor?
Yes, I think that is a factor. I think the profession is also innately quite conservative, but there is a large degree of ignorance both amongst lawyers and potential clients, and so I think that is one of the key reasons. And these things happen gradually. Having a lot of information in the legal press is something that's helpful, and actually lawyers will realise that from a compliance viewpoint, it's important to consider third-party funding because they're professionally obliged every time they take on a piece of litigation to advise the client as to the funding options.
And Kerry, I mean, what about? I mean, one of the things one hears a lot of is that the criteria which funders impose are just too tough. So very few cases will actually meet the threshold?
Well, I think although I agree with the definition in terms of the way it's accepted, it's in some ways a definition defined by the people supplying the products. How is third-party funding conceptually different from what insurance companies do, what trades unions have done for 150 odd years, what the when legal aid existed, what the Law Society did. The concept of society recognising that most people simply can't afford to go to law has been around for a very long time. I have absolutely no objection to third-party funding in any shape or form. But I think it's a self-fulfilling prophecy if you say, well, we insist on these criteria, very high value, and therefore will only be available for a limited number of cases. That answers its own question. Of course, it's not giving access to justice beyond a fairly narrow band. I think what's of much more interest is the potential for the classic definition of a third-party funder to be applied to the 60 million people in the United Kingdom. When you look at personal injury work, to say it's a mess is an understatement. I can't see such work remaining with solicitors' firms for more than a couple of hours after the 6th of October. There is no sense. They don't have the work. They don't have the finance. Alternative business structures, I think, will be a very, very different kettle of fish. There's reference to lawyers being innately conservative and ignorant and unaware. I think this has been broadcast later as lawyers, so I'll just go along with that rather than add a few other comments. But lawyers will not be the players in third-party funding or indeed the management of law. So I think there could be very positive developments. And to blame lawyers for not being good business people doesn't make a lot of sense to me. It's completely and utterly true, but let's have the lawyers doing the law, and if a third-party funder, forget the banks, their history, but a proper third-party funder, there's still significant money in the law, there's still a demand for law, then I think progressive lawyers would welcome that very much, and I think it could genuinely be a real replacement for legal aid. I'm not sure what consumer means, as I've said, but certainly personal injury work is ready-made for mass funding.
I'll come on in a moment to how this might extend into consumer markets. But Neil, from a funder's point of view at the moment, is it right that the number of claims being funded is in fact many factors higher than the 100?
Anecdotally, my suspicion would be that it's higher than the 100. I think the 100 is an underestimate. And I think one of the reasons for that is that most of the cases that are funded, the fact of the funding is not in the public domain. It's up to the client, usually whether or not the client wishes to advertise the funding. They may choose to, they may choose not to. And most of the funders would keep their activities close to their chest because of the reasons of privilege and confidentiality for the client. To pick up a point that Kerry made there, it's interesting that he says that lawyers should focus on being lawyers. One of the attractions, I think, of funding is that actually it does that. Rather than necessarily having the lawyers running a no-win, no-fee agreements, the funder provides the funds, the lawyer provides the advice, and the client provides the instructions. Everyone takes a natural role in that setup. I think it's also right probably to say that there is a lack of awareness amongst the legal profession about how to access the funding and how the funding works. There are probably relatively few firms that have dealt with it, and certainly dealt with it a lot, and would know how to be able to present a case to a funder to make it commercially accessible, make it investable as a product for the funder.
And Susan, obviously, one of the perspectives out there is to get a case funded, has to be of at least £2 million value, has to have 75% chance of success, and has to have an unquestionably solvent defendant. And we all know as lawyers that you will never get a process of success higher than 75%. So it's quite a high benchmark to start off with.
Yes, I think that's a bit of a myth that needs busting, actually. The enforceability point is never going to go away.
Yeah.
It doesn't matter how fabulous a case is. If the defendant hasn't got any money, it is simply a pointless exercise. So we're never going to get over that. That has to be our number one criteria. In terms of risk, though, I think that there's a bit of a myth around, and coupled with the cost point, people are sort of saying, oh, well, funders, they're too conservative. Well, if the costs weren't so expensive, and it's that which we have to cover all the costs and then seek to make a return, That's why the claim values tend to be high. Were the costs in this country either fixed and lower or just lower, then we would be able to fund much smaller cases. But you've got to have a situation where, if the costs are coming up close to the claim value, then there's no money for the claimant, there's no money for us. That doesn't make a business. But in terms of the risk, that there is no, we're not like after the event insurers, and that's not meant to sound pejorative, but we don't have a set percentage. And in fact, the other day we offered funding on a case where the insurer said it wouldn't insure because we had experience in that particular area, which meant that we could understand the information that was required to make the case good, and therefore able to make an offer on it. Percentages are meaningless, frankly. Each barrister's or solicitor's view of a percentage is different and highly subjective. Yep. It's for us to be able to look at a case and say, you know what, I like the facts, it's a bad story for the defendant, the law stacks up, we will fund this case. So I think it's a new campaign by Neil and me to start busting that myth.
I'd like to move on. We've been talking mainly about commercial claims. Angus, I know you've been, in your research, looking at the potential for the third-party funding model to extend into lower value claims, consumer claims, high street claims, however you want to categorise it. Is that going to work?
Well, I think, if I can just pick up on one point that I think Susan partially addressed in the last issue. The 2 million claim, one of the things that we're finding, also that we found in our research, is that we're generally speaking of claims of 100,000 and above. So to suggest that all claims have to be over the million or 2 million or that kind of thing, that's not the evidence that we're getting from various funders. Although higher value claims with, as Susan says, good law, good legal team in place, and a tangible outcome for the claimant, are actually obviously more attractive to the funder. As regards developing it into the consumer sector, we are already seeing signs that it is going to develop. I think the problem for the consumer sector is that it's going to need to be high volume, lower value cases in order for it to work properly. And that's probably just not attractive to many funders at the moment.
I was interested in your comment about you're seeing cases being funded of £100,000 at that sort of level. Malcolm, your research on how the economics actually work.
Yeah, I think our general perception is that third-party funding is commercial litigation, business-to-business type litigation, and I think that's the way Jackson wrote his report. That is not to say that there aren't other forms of funding out there for consumer claims. And I think in terms of consumers, if we think in terms of consumers as we describe the Sale of Goods Act or the Consumer Protection Act, that type of individual as opposed to a business sort of entity. Yeah. But there is models for that, and there's a lot of that in the US as well. There's a lot of settlement funding whereby a claimant sells his interest or a part of his interest in his claim before the case is decided in order to take some cash now. How he applies that cash is not necessarily for funding the litigation. It might be, but it might just be to sort of pay some medical bills or something like that. So economically, you can construct a model for that type of funding of settlements and litigation. The question I think we should be asking is whether it is actually desirable. And I think this perhaps relates to the definition of what do we mean by third-party funding. And then I think what society thinks is good for business-to-business people to make decisions on as compared to the man in the high street. And I think there are some real issues that haven't been grappled with in that connection.